Welcome to this training video presented by Sarah Neville from Knutsford Training and Consultancy on behalf of Childcare.co.uk. During this video, I'm going to talk about the General Data Protection Regulation, GDPR. I am not a GDPR expert. I have spoken to the Information Commissioner's Office at length, and I have taken advice from GDPR experts and other trainers before recording this presentation. However, if you want to check anything I have talked about, or you need further advice, you should contact ICO direct. I know that data protection isn't the most scintillating of topics, but we do need to cover this so everyone understands their responsibilities to comply with the new legislation. Under GDPR, we need evidence that we are compliant from the start. We need documents and processes in place to show we're following the regulations. Evidence that we are safeguarding data that we hold about children, their families, and staff. During this presentation, I will talk about two main areas of GDPR compliance. First, I'll discuss the background to GDPR, and then I will move on to look at documentation early years providers need to help comply with GDPR. The General Data Protection Regulation, GDPR, must be adhered to by all early years providers, including childminders, nurseries, preschools, before and after school clubs, by the 25th of May 2018. GDPR is EU legislation which will replace the current very out-of-date Data Protection Act, and the government have stated that it will be retained after Brexit. The Information Commissioner's Office will continue to regulate providers when GDPR is introduced, and the cost of annual membership with ICO has not increased if paid by direct debit. It's still £35 a year. There are two main roles under GDPR, the data controller and the data processor. You, your setting, are data controllers. You collect data about children and their families, and staff if you have any. I think it's important when considering what changes we're going to make to comply with a new piece of legislation that we learn as much about it as we can first. So here we go. I've heard a lot of comments from providers like, nobody will know if I don't do it, and who will police it? All I can say is, it's the law. The Information Commissioner's Office will regulate it. The fines for non-compliance are huge. It's up to you. I'm working with Childcare.co.uk to make compliance as easy as possible. Let's look at some basics first. GDPR relates to all sorts of personal data: name, date of birth, medical information, address. It covers online as well as paper data. There are 6 legal bases for processing data about children and their families. You can see them on this table with examples. These examples were given to me by ICO. Only 5 are relevant to the early years. Some are stronger than others. Consent is the weakest. Legal obligation and contract are the strongest. ICO tell me that legitimate interests is the most flexible. Because consent is the weakest, you need to be very careful when you use it, because it can be withdrawn at any time, and you must inform parents that they can withdraw it. There are 6 principles of GDPR. When you're thinking about processing data about children, their families and staff, processing must be fair, lawful and transparent. You must have a good reason for processing data. You can't collect it just in case. Data must be adequate for what you're doing. Not too much, but enough to allow you to do what you need to do. It must be accurate, so you need to think about how you'll update it to keep it accurate. How often you'll ask parents to update their contact details, for example. You must consider data retention in relation to the principles of GDPR. We'll look at this one in more detail later. And all individuals, parents and children and staff members have rights to confidentiality. It makes sense if you look at it like this, doesn't it? I've taken this picture from Google Images. Data transfers from one place to another, especially online, at such a fast rate, and we need to take care of it, especially when it belongs to children and their families. Add in a few staff members taking things home, multiple Facebook profiles, parents who share photos when they've been asked not to, and you could very quickly have a situation where you have a data breach. And I'll talk about data breaches later. Under GDPR, individuals, you, me, children's parents, children, and any staff we have more control over how data is used, how data is processed. This means that we'll need to be ready to explain our data processing to parents if they ask us. We have the right to be informed about data held about us. What do companies hold about you? You have the right to be informed as well. And children have the right to be informed when they're older. You will share this information on your privacy notice. You have the right of access to data, known as subject access requests. You can't charge anyone to look at the data you hold on them. So you need to think about how accessible it will be if they ask in a few years' time. Maybe now is a good time to go up into the loft and check everything you hold from a few years ago. GDPR is not retrospective, but it's a useful exercise in decluttering, and checking what you've got is relevant. You have a right to rectify data if it's wrong. Ask parents regularly, and staff, do they need to make any changes? How regularly? It's up to you. But decide it and put a note in your diary so you don't forget. There's a right to erasure. That's also known as a right to be forgotten, but it's not absolute. There are reasons why we can say, nope, I can't delete that information about you. They're mostly linked to the EYFS, or if you're in Scotland and Wales, to your legislation or to the Limitation Act. We have a right to restrict processing of data. Parents have a right to say, no, you can't do that. And we'll have to go back to our legal basis and check that we can, or say it's optional. There's a right to portability, a right to move data around. There's a right to object. We might say, I have a legitimate interest to process that data, and parents say, no, you haven't. And then you'll have to think about it carefully. Do I really have a legitimate interest? And you have rights in relation to automated data decision making and profiling. This is unlikely to affect us in the early years, but it might affect you personally, so it's important to know about it. You know, when you look at something on Amazon and a few minutes later you get an advert from it on Facebook, or you hit a big birthday and Facebook starts putting advertising links about your age on the profile. That's automated decision making and profiling, and you'll find more information on the ICO website. Think of a privacy impact assessment like a risk assessment. It helps you to recognise and minimise risk. The EYFS statutory framework in England says that risk assessments don't need to be in writing if you can explain them when asked. The Scottish and Welsh Childminders and other early years providers, you'll need to check the wording in your own statutory framework. You should do a risk assessment in high risk cases. For example, if you buy some new technology or you start using a new piece of software, be proactive. Think about the impact it will have on data. Take advice if necessary. Be sure that it's safe and secure first. It's like the process you go through when you get a new mobile phone. You wouldn't go online without an antivirus, would you? Well, don't put children or family details on something without checking they're secure. Think about memory cards, external hard drives, memory sticks, laptops that travel between settings. If you offer 50/50 childcare, for example, how do you keep those secure? Are they encrypted? There's no absolute requirement in GDPR to encrypt data, but it must be secure. And you don't want to have a data breach and be told you didn't take appropriate care of the data. This is an area of GDPR that is causing a lot of confusion at the moment. We need to comply with GDPR and the Limitation Act 1980, and in England the Early Years Foundation Stage and the Childcare Register, and in Scotland and Wales you need to comply with your own legislation. I've written a sample retention policy, and you might add to it or take bits away from it if they're not relevant. In relation to GDPR in England, this is what it says in the EYFS, and it's a little bit vague. We've tried to find a legal definition for a reasonable period of time and failed. And this is when companies and trainers and advisors start to make things up, and often the information out there is wrong, so you do need to be careful. The Childcare Register, which is used for children over the age of 5 in England, is a little more specific. But it doesn't link to the Limitation Act 1980, which is law, and insurance companies use the Limitation Act when expecting us to keep certain documents. As I say, I've written guidance, but that's exactly what it is, guidance. I've done my best after a lot of conversations with ICO. Make of it what you will. Now let's move on to documentation for GDPR. For many providers, this new legislation has led to time spent checking documentation and ensuring it's GDPR compliant. Those providers resistant to change have felt it's an intrusion on their already busy days. And yes, it is. There is a certain amount of things we have to do. While for many, they've seen it as the ideal opportunity to give their documents, files and folders a wash and brush up. I think it's really important to treat this as a time to refresh your documents. I printed all of mine. I've checked through them. I've made sure I'm not duplicating, not asking questions I cannot justify. If you use online systems to process data, you must be confident that they're secure and ask the same questions you would do when checking your paper documents. Am I duplicating? Is that information necessary? The first document, the first thing you need to do as part of GDPR compliance is your data audit. Are your questions fair and lawful, as required by the principles of GDPR? Do I reflect parents' rights to be informed about what data I hold about them and their child and staff, as required by the rights for individuals in GDPR? Am I asking parents for more information than is covered by the 6 legal bases? Do questions need to be optional? I work with my husband, so I don't have any data about him. But if I had staff, I would need to do an audit of their data as well. Staff data should be in a locked file or cupboard, treated confidentially. Don't leave it lying around when you do a new parent show round or at the weekend for your own family to see. We need to think about security as well. Paper should be secure, locked away ideally. Children's data should be filed away, and when you're finished with it, put it in a separate envelope or file and label it with when it needs to be destroyed. Think about digital security. As we've already said, logins, change your password, update your antivirus, auto lock on tablets, things like that. When you're writing your privacy notice, I used ICO as a guide for writing this one for Childcare.co.uk. There's an awful lot of information online, but some of it is confusing. You need to make sure it's written in plain English, no here twos and forthwiths. Plain English that all parents can relate to and understand. A privacy notice must tell parents exactly what data is collected and why, how it's used, what you will do with it when the child leaves, and how they can make a complaint to ICO if there's a data breach. ICO says we should consider creating child-friendly privacy notices too, if we're dealing with older children's data, to explain to them in language they understand about the data we hold about them. I haven't written that yet, but it's something I will look into in the future. Data sharing agreements are recommended by ICO and GDPR. They're not a requirement. They're used when you share information about children and their families or staff members with other professionals or agencies. It's your responsibility to ensure any third party you use is secure. That might relate to, for example, a staff member's training company, your accountant, online cloud storage, or photo processing companies which are out of the EU, or your learning journey software company. ICO distinguish between agreements, data sharing agreements for controller-controller relationships. Remember, you're the controller. And contracts for controller-processor relationships. You will find more information about that on the ICO website. You might need to update some of your policies. I can't advise on that specifically because I don't know what's already in them, but I have shared my policies and procedures and how I've updated them for GDPR on the Childcare.co.uk Gold Members page. And I've updated the acknowledgement of receipt so that you can add your privacy notice and your new retention policy to it. It's a very flexible form, that one, so you can put your own information in. I've used GDPR as a good reason to update some of my documents as well, and you'll find them on the Childcare.co.uk free childminder paperwork site. For example, the accident forms. I've changed to a little tick box there which confirms the witness has consented to share their information. Tick boxes are fine if they're clear and you've got a good reason for asking for them. And it allows your witness to say, yes, I'm happy for this information to be shared, because of course you might want to share it with Riddle or Ofsted or another agency. On the child record forms, I've checked them with regard to data minimisation because that's an important part of GDPR. I've made sure that questions are not duplicating information I've gathered elsewhere. Alongside the child record forms, I have an emergency contact details form if parents can't collect their child or if there's something wrong with me, so that I have someone else's details, grandparents, aunts and uncles, whoever, and so do emergency services. I've added a tick box there to show that these contents have given their permission for their details to be shared. I've added some information to the contract termination letter about data retention. We give parents the data retention policy at the start of their contract, but it makes sense to me to remind them when their child leaves that this is what we do with your child's data. So I'm giving it at the end as well as the beginning. And I've updated the parent-provider contract, again with an eye on data minimization and duplication, and I've made a few tweaks. So if you use those documents from childcare.co.uk, you will want to download the new versions and start using those. This is the form, the permission form, that took me the longest to get right. Because there's so much information and misinformation, I talk to ICO to check different sections. Consent, as we've already said, must be specific and freely given and informed and not ambiguous. Those forms that are pre-ticked to assume consent, those forms that say, tick here if you don't want to do something, and make it complicated to know what they're doing, have got to go. You can still have tick boxes, but it must be a clear yes or no tick box. And you must tell parents that they can change their minds. If you need to process special category data and use explicit consent as your legal basis, if you look on the ICO website, there's a difference between consent and explicit consent. The parent or the staff member has to agree to this in writing, saying, I agree, rather than a yes-no tick box. But in most cases, a yes-no tick box is enough to cover you. I've written a training course for staff with handouts and scenarios that managers can use to discuss during training. It's important that training provides each staff member with the information they need to do their job effectively. You've no need to overwhelm them with things they don't need to know about. But your training does need to ensure that they protect you and your business from data breaches. A data breach register, again, has been provided. You need to know what a data breach is first, and the register gives you lots of examples. It's when someone who shouldn't have been informed about a child or family does have that information. It's when someone gets hold of something they shouldn't have. It's when data becomes inaccessible. You've destroyed a file by accident, or there's a hard drive failure. You need ways to detect a data breach. You need to record a data breach. You have a sample form in this document. You need to investigate it. And if it affects the freedoms or rights of staff, children or parents, then you must report it within 72 hours to ICO and to the affected staff or parents. You need to think about how long you're keeping data about children and their families. As I've already said, I have written a retention policy and it's on the Childcare.co.uk website. And sometimes it is, by necessity, vague. That's because you might have a good reason for keeping things for longer than ICO state. As long as you've done this three-part test, it's described in more detail on the ICO Legitimate Interests page, then you're covered. ICO call it a legitimate interests assessment. Think of it like a risk assessment for data. Part 1. Have you identified a legitimate interest for keeping that document? Why are you keeping those attendance registers and those contracts alongside those accident and medication forms? For example, I have a legitimate interest in keeping those together because I think in the future, if there's a claim made against me, I might need to prove when the child was and was not in my setting. That is my legitimate interest. Have you shown the processing is necessary to achieve it? Well, yes, because if I shred that or I delete that, then it's gone and I can't show that evidence. Have I balanced that against an individual's rights, interests and freedoms? Yes, I have. I've informed parents what I'm doing and why. They know they have the right to object. And if it comes up in the future, I will look at it again and I will take advice from ICO. When we're talking about data disposal, we need to think about how data is kept secure when we're disposing of it. If you sell a laptop, for example, are you sure all the data's gone? Photos as well as documents, passwords, if anything's kept in the cloud, are you sure that they've been removed? With paper disposal, shred it. Don't just put it in the bin. Think about notes you write about children as well as forms you complete. Make sure your data disposal is robust and that it's carried out at the time stated in your retention policy. I hope you found this video useful and informative. It's one in a series of videos to support early years providers with GDPR compliance. We have a GDPR and photos presentation. As we've already seen, there's lots of GDPR documentation and staff GDPR documentation. Thank you to Childcare.co.uk for commissioning these videos about GDPR to support all early years providers.